we'll go ahead and get started with our first oral argument of the day, which is Jennifer Anderson versus Wells Fargo Clearing Services, LLC. 128403, counsel, come on up, and then I will take appearances from the parties. For the appellant.
Good morning, Your Honor. Eric Martin.
And Alan Root.
Very good. And for the appellee?
The appellee is Chris Steinkamp and Braxton Morrell of Pew, Gill, and Rathman and McIntyre. And our client, Jennifer Anderson, is also here in the courtroom observing.
Thank you, counsel.
Thank you.
You may commence and let me know, appellant, if you'd like any rebuttal time, please.
Yes, Your Honor, if I may have 3 minutes of rebuttal.
Very good.
May it please the court. My name is Eric Martin, and I'm here with Alan Roop. We're representing Wells Fargo Clearing Services in this appeal. And this court should reverse the trial court's denial of the motion to compel arbitration. And essentially, there are two main reasons why it should do so. First, the arbitration provision in Mr. Gates' account agreement applies to Jennifer Anderson as the successor trustee of the trust because she is a successor under the language of the account agreement. And second, equitable principles apply such that when one is claiming or basing claims upon a contract, they cannot deny other parts of the contract, such as the arbitration provision. Now, first, in examining the issue of why Ms. Anderson would be bound by the account document, so this was a brokerage account that was established by Mr. Gates in 2013. When he did so, he was required to sign an account agreement, which is very common in the brokerage industry. And that agreement is going to govern the relationship regarding that account. And the account was subject to the normal provisions, such as any disputes, any and all disputes arising from this agreement or any other agreement is going to be governed by an arbitration provision that would submit any disputes to FINRA arbitration. FINRA being that forum which is set up to resolve disputes in the securities industry. Now, the language very clearly said that it applied to a litany of heirs, executors, administrators, successors, and assigns. And it's the successors language that we would focus on this morning and that our motion to compel arbitration focused on, in that Ms. Anderson would be a successor under that language.
Let me stop. Go ahead.
No, yes.
Go ahead. Well, when we look at the account agreement, yes, doesn't it also contain a choice of law clause for New York law, not for Kansas law? And we've heard only Kansas law in your brief.
It does. Some of these threshold issues, such as contract formation and who is covered, often the law of the forum jurisdiction is used for that. So that's why I think the parties were focusing on the Kansas part of that law. Ms. Anderson is claiming that there's no contract formation, and so as a result, we used Kansas principles to explain why indeed there was and why that would be covered. But you are correct, it does have a New York choice of law provision.
And let me stop you.
Yes.
So we're talking about her status as a successor, but what was missing from the record, I think, is the document where she or the trust is designated a pay-on-death beneficiary. Is that correct? Is it in the record?
So the parties acknowledge, and the plaintiff concedes that is the designation, that's a transfer on death designation. You're correct that the record doesn't actually have the actual transfer on death designation, but that designation is a mere ministerial type of document.
But
Yes.
is there a difference between a transfer on death and a pay on death? And do the parties agree what this is?
It has been described in the pleadings by both parties as a transfer on death situation, document, agreement. And as a result of that, yes, I think the record would be clear that that is what the parties understand to govern this dispute, that is a transfer on death. Ultimately, I think it would be a matter without distinction because, and this is something that the trial court took a bit of a tangent on, when it focused on whether Ms. Anderson was just merely a payee, whether she was just merely a payee under the agreement. That's a distinction. For one thing, it's incorrect, but it's a distinction without a difference because just as a life insurance beneficiary would be a recipient, would be a payee of those funds, we cited case law showing that even in those contexts, that beneficiary is going to be governed by the arbitration provision in the policyholder's policy. So that's a distinction without a difference. Here, there's no doubt that she was a successor.
Is successor defined in the agreement? So I'm looking at the agreement, and subsection 2 has the definitions of the various terms, and it includes a definition for party or parties, which says means you and Wells Fargo advisors together with their affiliates collectively. But where do we see the definitions of the terms successor, heir, et cetera, executor, administrator? Are they anywhere in the document, or are we left to interpret those?
Your Honor, I don't believe they are specifically defined in the document. Instead, they're listed underneath the scope provision, which is on page 15 of 52 of the document, which provides that, again, all of this is going to be binding now and in the future upon heirs, executors, administrators, successors, and assigns. So those words we would give common meaning to in terms of legal status. And that was one of the reasons that we cited the Kansas Transfer on Death Act, which talks about the fact that these types of accounts are one in which an owner, present owner, designates a future owner of the account. And here, Ms. Anderson clearly was exercising ownership of the account when she submitted a letter of authorization directing that the funds be transferred.
But that was at that was at Wells Fargo's direction, correct? She didn't just come up with that transfer letter on her own. Wells Fargo required her to do that.
That's correct, Your Honor, because her only rights exist through the contract. If she were to, as a successor trustee of this trust, have come to Wells Fargo and said, please send the funds to me, she would have absolutely no right to do so unless there was a contract that governed that, a contract that established the relationship. And so, yes, she did use the Wells Fargo forms in order to accomplish that, but the reason that that procedure was there was because she could only take rights through the contract. Interestingly, at one point, one of the arguments that plaintiff makes in this case is that she directed that the account be closed, and therefore the arbitration provision should not apply after that. Now, we address that. The agreement clearly says that those provisions survive the termination of the account. But that admission is telling. By what authority was she asking to close the account? She was absolutely exercising ownership rights with that successor type of status that she had by virtue of the type of the account that it is. So I think that we can look at the plain meaning of that language to understand that successor is someone who's going to have control, authority, the ability to exercise rights. Those rights come through the contract, and as a result, that's why she would be bound by the contract. Under the plain language, as a successor, she would be bound. So we cite in our brief, again, the Transfer on Death, the TOD Security Registration Act.
Let me stop you.
Yes.
Did you specifically raise the application of that act in district court?
Your Honor, our main leadoff argument, if you look at our motion to compel, is that she was the successor trustee. That particular statute wasn't mentioned in the brief, but that would be no different than making a motion on a will and then later citing a statute about the effect of wills. That's just a legal principle. It's just an explanatory principle. It's not a new argument in terms of introducing something. So as we addressed in our brief, that's not, again, this is a legal effect. It's a legal argument based upon the statute. But regardless, the contract itself is very clear that she had to take steps through that contract in order to do so. And if you look at...
Counsel, can I back you up a little bit?
Sure.
I'm sorry, I'm still... thinking, when you're talking about, when you're relying on the transfer on death, or the TOD Act, isn't that is beyond, that's beyond the formation of the contract, which you've cited Kansas law for. Would we not now need to be looking at New York law in interpreting that act?
So it would be a Kansas transfer on death procedure, since we're here in this state. The only real interpretation, Your Honor, would be, is the transfer on death portion of this covered by the account agreement? And the account agreement has very broad language about this agreement or any other agreement. It covers that. To the extent there's any dispute about whether it covers that, as we noted, that question's been delegated to the arbitrator. Under this court's Suchan precedent, that threshold question would be delegated. So in answer to your question, it's a very, I think the Kansas, again, transfer on death statutory scheme is relevant here, but it's really simply general contract principles about how broad that scope is. And the contract could not be more clear that it applies to this agreement and any other agreements. And again, the transfer on death portion is going to be simply a ministerial type of, beneficiary type designation. In other words, directing where the funds will go in the account. So I think that just based upon those general contractual principles, we're well equipped to address that. I do also want to make a point that the case law that we cite from the District Court of Kansas, which has dealt with some of these principles, I think is very telling. In the Weishar case, in that case, the court held that you could enforce an employment agreement signed by a predecessor because there was some successor and assigns language. Similarly, in the Funderburk case, the District Court of Kansas, in that case, there was an arbitration provision in a credit card agreement, and there was an assignment clause, meaning that a later company could do so. Contrast that with the Gwynn case, where a present employer was not able to enforce an employment agreement with a predecessor because there was not such language. Here, we have that language spot on that allows Wells Fargo, both sides, to enforce this account agreement and the provisions therein based upon that language in the agreement.
Counsel, you're getting into your rebuttal time. You're free to do that.
Let me just quickly say, Your Honor, that on the equitable estoppel grounds, this court has already recognized in the Hemphill case that it's possible for contracts to be enforced against non-signatories. That's something that this court has established, and we cite Decant Authority, which recognizes the plethora of case law out there that non-signatories can be bound. And basically, if rights are granted under a contract, they're governed by that contract. You can't pick and choose. Here, Ms. Anderson is seeking to enforce the transfer on death, the account agreement, and because she's doing so, she can't ignore the fact that that also is governed by an arbitration provision. And with that, I'll save the rest for my rebuttal.
Thank you, counsel.
Thank you.
Counsel for Appellee.
Thank you. May it please the court. I'm going to try to just focus on the issues raised by Mr. Martin. In his argument, you have our briefs that respond to a lot of the things that are otherwise involved in this matter. One thing that's important to understand here is this is not an account transfer order. It is a pay on death order for a cash account. It is repeatedly referred to by the defendant as a cash account. It, at all relevant times in this matter, had cash in it and nothing else. It didn't have any securities. It wasn't anything but more than a cash account. And they have tried to change it to be something else so that they can bring in arguments under the securities transfer on death statute in Kansas, which is inapplicable, and it wasn't raised under at the court below. The second thing that's important to understand about this is Wells Fargo understood when it was asking for a litany of things from our client for her to continue to send more information and more things. When they sent the letter of authorization, if you look at that document in the record, you will see that it says very clearly, check, payee information, make check payable to, with the blank that our client filled in for the trust, because the trust was the payee, which they well knew. For them to now say that, well, we've transferred this account to the trust is not accurate. Their order, we believe, and has been admitted by them, I think, just said to pay the money because there was only money there. There wasn't anything else to transfer. And it is interesting to me that while they have produced tens of pages of documents for account agreements and different things, which are very complicated in two-point type, they have not produced the pay on death order. And we don't have a copy of it. So I'm assuming that it probably doesn't say anything that helps them, because when you look at their letter of authorization, it doesn't say anything that helps them either. So, and you've seen in the briefs, there was a litany of requests for information. They would lose the documents. We'd send it again. They knew every single thing. By the time they get down to this trustee certification of investment powers, they already had an entire copy of the trust. For them to demand that is ridiculous, frankly. It was purely a method to delay.
I'm gonna stop you for a second.
Sure.
So do we have a choice of law issue, and if so, what do we do with it? I'm looking at paragraph 14, volume 1, page 45, governing law and language. This agreement shall be deemed to have been made in the state of New York and shall be construed and the rights and liabilities of the parties determined in accordance with the laws of the state of New York without regard to choice of law provisions. And yet neither party has discussed this case under the applicability of New York law. So what do we do with this contract term?
Well, Your Honor, I think that under the clear terms of the contract, there isn't really a legal question. I mean, it says what it says, and they've not pointed to anything that says anything different. We think we're entitled to the money under the clear terms of the contract. And
if we look at like just general contract interpretation rules, you know, meeting the minds, things like that. I mean, do the parties agree we can do that under Kansas law, or do we need to look at that under New York law?
I think to the extent that the defendant was going to assert New York law, they've waived any opportunity to do that at this point, because they've never raised that issue one time. And Judge Calmer found that there was no contract between my client, the trustee of the trust, and the defendant, Wells Fargo. The only contracts that were signed were between the decedent, Mr. Gates, and Wells Fargo. And there is a list of entities that are bound, and those are heirs and successors and assigns, none of which we are. And the court specifically found that we are not. We are a payee. And it's also important to know that when we sent a demand letter from our law firm to Wells Fargo, and they gave us yet another runaround sort of letter, and we decided it was time after 7 months just to file a lawsuit. They, within 16 days, paid the money. When we got to the district court, Mr. Martin explained to Judge Calmer that they were only trying to make sure that they were paying the right person, and they didn't have any other concerns about paying. Well, clearly they've changed their position since then. And they cite that exchange in their briefs multiple times about Judge Calmer saying, you know, isn't this really just kind of like an insurance policy, and you've got a designated person to get paid, and when you get the notice of who, you know, that somebody's died, that you pay the money. And they said, well, we're just trying to make sure that we're paying the right person because we get sued. Well, if you look at all the different things that they've asked for here, that's clearly not what they were doing. And the other thing that's very interesting is after they paid the check, they filed an answer. And in that answer, they admitted that our client is a payee. They admitted that our client is a payee. We're not a transferee, we're not a successor, we're not an heir, we're a payee, period. And they admitted that in their answer, which they filed at the same time they filed a motion to compel arbitration. And if you look at the list of parties who are covered by the arbitration provision, and in fact the account agreements, we're not on that list. And that's exactly what Judge Comer found, and he was right about that. And we all know what those various individuals are. You know, an heir, they know who the heirs are because they made our client send them a small estates affidavit listing who all the heirs at law are. So they knew who they were. They certainly knew who the trust was because it was the payee. We're not an assign, we're a payee, as they've admitted, and they've continually referred to this account as a cash account for which our only connection is to be a payee. And based on that, they've then tried to argue, well, if you try to do anything else besides get paid, you're taking control of this account. Well, no, not true. We have the right to recover property that we're entitled to own. That was their client, Mr. Gates's property that he assigned to be paid to his trust, and we're entitled to get that. Now, they sent our client all kinds of forms made out by lawyers designed to get her to sign off on all kinds of different things, which she did before she came to us. And, I mean, I don't think, honestly, she hurt herself because if you look at this letter of authorization, it clearly identifies that they know what a payee is. It's where you send the check. And that's what we're asking for here, is for this court to recognize that Judge Comer is exactly correct. We're not a transferee of a security. We're not a transferee of an account. We have no interest in having an account. In fact, I believe in the record is emails from our client, Mrs. Anderson, saying, I have no intention of ever having an account, assuming an account, doing anything else with Wells Fargo ever. Just pay me the money, which they, of course, did not until we filed a lawsuit. And then they immediately paid it before they'd even filed an answer. So if they had any claims or any defenses about whether we're the right person or whether we're any of those kind of things, they clearly waived all those defenses when they paid the money, before they even bothered to file a lawsuit or file a motion to compel arbitration or any of that that's landed us here today. So, you know, there's no securities getting transferred under New York law, Kansas law, or any other law. This is just a bunch of cash they're supposed to write a check for. And we have that check that they sent us immediately when we sued them now, honestly. But the dispute is, do they get to just wait till they get sued, having run our clients through the ringer and have her incur a whole bunch of legal expenses and other sorts of things before they decide they're going to pay? So, the specific words are an heir. Well, we know who an heir is because there's a small estates affidavit. Executors, we know who an executor is, and we're not an executor because, as they admit, we're a payee. An administrator, well, we know what that is. An administrator is an intestate party's probate administrator. We're not that. Again, we're a payee. And we're not an assign because we're a pay-on-death beneficiary, as they've admitted. Mr. Gates did not assign this account to his trust. He directed that a cash account, which was cash at all relevant times, I don't know what all may have gone on in that account in times past, but at all relevant times, it had cash in it and nothing else. And he directed that that money be paid to his trust, period. He didn't say, I want to assign this account to my trust because I've got a bunch of great investments in here. He just said, pay the money, which they wouldn't do.
Do you know whether it was considered a brokerage account under the terms of his account agreement?
I honestly don't know for sure. They have referred to it as a cash account, but I don't know whether it would have been considered to be a brokerage account or not. I would also point out in the account agreement, it has a paragraph on page 6, I believe, that basically says all of the terms of all of these different things and whatever we may add on for different bells and whistles that you may adopt from time to time are all incorporated into this document as if they were present at the moment it was first executed. So I know that in their briefs, they have picked out some things and said, well, there could be third-party beneficiaries because this third-party beneficiary thing that says there can be no third-party beneficiaries is actually in this separate kind of account kind of form or whatever, which I don't know if that applies or not. It looks to me like it's probably some kind of a cash account. However, I don't know their system. But it doesn't matter because their agreement says if we send you more stuff and we add on more bells and whistles, all of the terms of all of that stuff is incorporated as if it was here the first day you signed it. So the no third-party beneficiaries language is part of this account agreement, and they've tried to argue that we're trying to be a third-party beneficiary or something like that, which is absolutely not true. I mean, what we have here is money that is owned by the trust that we are trying desperately to get, and they have continued to throw up roadblocks to giving it to us. And so that's why we're here. It's not because we wanted to take over securities. The other thing that was raised here a minute ago was the termination. And again, that was solicited by Wells Fargo to Mrs. Anderson during the course of them asking for all kinds of information. And she, I think, sent them a note saying, look, just close the account, send us the money. And so based on their suggestion about something to do, she made some errant statement that she had no concept. I mean, she wasn't represented by counsel, obviously Wells Fargo was. And the fact that they may have invited her into saying something that there's now one statement that they claim, oh, well, you tried to take dominion. No, we just wanted our money. That's all we wanted. That's all we've asked for. We can't seem to get it. Yes? I'm sorry, I thought you had a question. The other thing that they said repeatedly is we would have no right to the money except for these account agreements. Well, I mean, that just isn't true as a matter of law. Even in New York, if somebody else has your money, you're entitled to get it. They don't get title to your money because they just happen to have it. That's called stealing, even in New York. And so that's the issue here. We're trying to get money that they have, that their client, Mr. Gates, directed them to pay to us, which they haven't done. We have common law rights. We own that money. They don't have any rights to the money. They've tried to claim, well, we're just a custodian. Well, maybe not, because at the same time they say, well, you don't have any right to this money and you wouldn't be able to get it from us if we didn't have these account agreements. Well, I think that's preposterous, frankly. So I honestly think that this matter is very straightforward. Our client did not sign any agreement with Wells Fargo at any time. She is not one of the listed parties that is also bound by the agreement because she is a payee as admitted by the defendant. And we believe that Judge Commer's decision denying arbitration is correct and appropriate, and we would ask this court to affirm the trial court. Thank you.
Thank you, counsel. You have 2 minutes for rebuttal.
Thank you very much, Your Honor. To pick up on what Mr. Steinkamp said there at the end, the trust had absolutely no right to these funds absent the contract. This would have had to go to probate, right, in the absence of any sort of contract. Because this contract, because this account, because it was subject to being transferred in a way outside of probate, absolutely the trust, Ms. Anderson, a successor trustee, had to go through that contract, had no rights but for that contract. And the fact that she may be a payee, that doesn't change the fact that she also had rights to those proceeds as the successor trustee. And again, those come through the account. So I think that really sums up the entire issue on that first argument. For her to have any ability as a successor trustee to get those funds, had to have a contractual right to do it. That contract has an arbitration provision, and she is subject to it. There was a lot of talk about the merits of the case, and if you look at the transcript, Judge Comer, 75% of the hearing is talking about the transcripts, about why did Wells Fargo take so long and all that sort of thing. I just want to be very clear, Wells Fargo's never said that it was not going to pay funds out of the account. There was a process to do so. It took longer than Ms. Anderson wanted. She's raised claims because of that. There's never any indication, never any statement at all that Wells Fargo was not eventually going to do that. It had a process.
How long did it take?
Well, it took, I believe, the August 31st submission was made, and I think the check was sent in April, if I'm not mistaken. So it did take some time, and she's trying to bring claims arising from that. Those claims belong in FINRA. That was the expectation of the parties when the account agreement was signed. That's the expectation, the commercial expectations that arise from that. So to the extent that she can raise any claims regarding any perceived delay from that, FINRA provides a forum. We're not saying she can't raise claims. It's just simply they have to be in FINRA. She's going through the account agreement. Her status to obtain these funds is through the account agreement, so therefore she must abide by that account agreement in that manner. Really quick on the law. So I think that the general principles here are going to be applicable to Kansas or New York. We're happy to file a supplemental memo on any sort of New York law. But I will mention also that we note that the Federal Arbitration Act governs this. It overlays state law in this regard, and we do cite several cases invoking the Federal Arbitration Act, both for its liberal policy of favoring arbitration and also the fact that there are situations where non-signatories can be bound. And again, we have language that allows this plaintiff to be bound, but also through equitable principles going through that contract to be bound as well. So in sum, we respectfully request that this court reverse the trial court with orders to compel arbitration. That was the expectation of the parties. That's what the plain language of the agreement provides, and that's what equitable principles mandate. Thank you.
Thank you to both counsel. We will take the case under advisement and get you a decision when we can.